5 seconds to go. Start. Thereafter, impugned order dated 13th June 2019 has been passed, by which the objections filed by the petitioner have been dismissed and warrant of possession has been ordered to be issued. Mr. B. S. Chauhan, learned senior counsel appearing for the petitioner, has argued that once learned executing court in its wisdom on 29th March 2017 had ordered the framing of issues, then the act of the learned executing court of unilaterally and suo motu reviewing the same wide order dated 7th May 2019 is not sustainable in law because no reasons stand mentioned by the learned executing court in its order dated 7th May 2019 as to why there was a change in heart and as to why learned executing court was of the view that the case was inadvertently listed for determination of points on previous occasion. Learned senior counsel has argued that once there was an order for framing of issues, then learned executing court was bound to have had framed the issues, and after calling upon the parties to record their evidence in support of their respective contentions qua the issues, appropriate order should have been passed by the learned executing court on the objections. Failure on the part of the learned executing court to do so has resulted in grave injustice to the petitioner, and in this background learned senior counsel submits that the impugned order be set aside and the case be remanded back to the learned executing court for adjudication afresh after framing the issues. Opposing the petition, Mr. Praveen Chandel, learned counsel for the respondent, has submitted that there is no infirmity in the order passed by learned executing court on 7th May 2019, by which it ordered that a case was inadvertently listed for determination of points because in the absence of any compromise having been entered into between the parties, there was no need to frame any issue. He further submitted that on 17th May 2019, when the order was passed by learned executing court, no objections were raised qua the said order by the judgment debtor, nor any protest was made thereafter, and it is only because the main objections have been decided against the present petitioner that this petition has been filed to defeat the ends of justice. On these basis, he submitted that the present petition be dismissed. I have heard learned counsel appearing for the parties and also gone through the impugned orders as well as the documents appended with the petition. Under the provisions of section 115 of the Code of Civil Procedure, the High Court interferes with the orders passed by the learned courts below on the happening of any of the following three things. If the impugned order has been passed by the court by exercising jurisdiction not vested in it, if the impugned order has been passed by the court by not exercising jurisdiction vested in it, and or if the impugned order has been passed by the court below by exercising jurisdiction vested in it with material irregularity. In the considered view of this court, this case falls in the third category. No doubt there was no bar for the learned executing court to have decided the objections to the execution either by framing the issues or without framing the issues, but once order stood passed by the learned executing court that issues are required to be framed for the purpose of determination of the objections, then the act of learned executing court of arbitrarily recalling said order, void order dated 7th May 2019, which is completely a non-speaking order as it does not reflects as to how learned executing court came to the conclusion. Stop.